My name is Marilyn Nash, and I'm the Interim Assistant Regional Director and Regional Outreach Officer for the Midwest Elijah J. McCoy Regional Outreach Office here in Detroit, Michigan. And joining me online today to assist are my colleagues Ken Takeda from our Western Regional Outreach Office in San Jose, California, and Tamika Obashan, who's located in our Northeast Regional Outreach Office at Alexandria, Virginia. Just as a note, housekeeping note, please submit your questions in our chat function today, and that will come to us. We will be providing answers throughout the presentation, so feel free to ask those questions. And if you're looking for a copy of today's presentation, I will ask that you email midwest@uspto.gov to request a copy. So with that, let's go ahead and get started with today's presentation. So before we continue, I do want to give a brief disclaimer that the information presented today is for informational purposes only and should not be considered as legal advice. We do ask that you consult with the appropriate sources for legal authority and for guidance on these matters. Okay. So I'd like to just start with an overview of USPTO. The USPTO, United States Patent and Trademark Office, is an agency within the Department of Commerce with more than 14,000 employees, including approximately 9,000 patent examiners and more than 760 trademark examining attorneys. We are the federal agency that grants patents and registers trademarks, as our name implies. The USPTO is a fee-based federal agency, meaning that we do not receive taxpayer dollars. We operate from fees we collect from patent and trademark applicants and other users of our systems. With that said, we receive approximately $4.5 billion annually from fees. And as we look here, the stats on the screen during fiscal year 2024, we received some 660,000 patent applications, and during that time granted 365,000 patents. During that time, we also received about 767,000 trademark applications and registered nearly 338,000 U.S. trademarks. We are headquartered in Alexandria, Virginia, and there are regional offices as well located in Detroit, Michigan, San Jose, California, Dallas, Texas. We also have the Northeast and Southeast regional offices located at headquarters, co-located there in Alexandria, Virginia, as well as a community outreach office in Durham, New Hampshire. So pictured here is an overview of the patent process. And the idea for today's presentation is to give you a solid foundation for the upcoming Path to a Patent sessions, which will really dig into the patent process in more detail. As I mentioned before, it is strongly encouraged to pursue your intellectual property rights with the help of an attorney in the field of your invention, because that will allow you to obtain your rights more efficiently. With that being said, the cost of an attorney plus the USPTO fees could add up quickly. So it is important that whoever's pursuing a patent or a trademark should have a strong knowledge base and understanding of the process. So once you have completed the series, you'll have the IP knowledge and foundation to have a productive, effective talk with your attorney. And we all know attorneys charge by the hour. So when it comes to those discussions, being educated on your IP, your attorney will spend less time educating you and more time focused on your invention. So what is intellectual property, or IP for short? Here we have two types of properties pictured, and you can own or they may or may not have value, right? So as we see on the left, you have an example of real or physical property like this house and the land that it sits on. And on the right, intellectual property, or as I said, IP, which is an intangible property, which are creations of human intellect. Examples of IP include inventions, literary and artistic works, designs and symbols, names and images used in commerce. Similar to the fence that defines the physical boundaries of property that belongs to you, intellectual property defines the metes and bounds, or the legal fence around intangible property like your idea. And the legal ownership of intellectual property allows its owner to exclude other people from using the ideas or concepts that comprise the intellectual property at issue. Now, the first step is to determine the type of IP protection that you need for your idea. And so you've probably heard about types of IP, but what exactly are they and how do they protect you and your IP? So when we look at the types of IP, there are four main types of intellectual property in the United States. We have patents, trademarks, copyrights, and trade secrets. Let's quickly review these for now, but I'll go into a little bit more detail in the following sections. So first with patents, it will give you the legal right to exclude others from making, selling, using, or importing your claimed invention for a limited term. That term could be 15 or 20 years, depending on the type of patent that it is. When we turn to trademarks, it protects brands as well as consumers because trademarks identify the source of goods or services. It allows customers to know who they're doing business with, and the term for protection lasts for as long as the mark is in continuous use in commerce in connection with the goods or service. Now, when we look at copyrights, copyrights protect creative works. So think in terms of music, books, choreography. The term for copyrights is the life of the author plus 70 years from the author's death. For works made for hire and anonymous works, copyright protection would be 95 years from publication or 120 years from creation, whichever is shorter. And then finally, we have trade secrets, which are just what they sound like, secrets. And the effectiveness of trade secret is determined by how well you or your organization can keep the idea under wraps. So I just want to make one last point here before we continue. And it's important to understand, previously I mentioned that these are the four types of IP in the United States. These forms of IP may not be the same in other countries, and that's because all intellectual property is territorial, meaning that every country has its own intellectual property laws and regulations that may differ from United States IP laws and regulations. Let's begin with trade secrets. So, what is a trade secret? A trade secret protects proprietary information that gives a competitive advantage, but those trade secrets must be maintained secrets. Companies must make a reasonable effort to preserve the trade secret, and generally they may be protected within a company by signed agreements between the employees and the company. These contracts may require non-disclosure of proprietary information and non-competition after leaving employment. This is a good example of what falls within the reasonable effort to maintain secrecy and to keep information out of the public domain. However, with these legal agreements, you may lose the benefit, without these legal agreements, I should state, you may lose the benefit of your trade secret. Another way you lose your trade secret is by competitors reverse engineering your product, which is why we often don't see a physical machine or apparatus being a trade secret, because someone could simply take that machine or apparatus and rebuild it to understand how it functions. Benefits of a trade secret is that it may last forever if you are able to maintain that secret, right? Whereas a patent, as I mentioned, has a limited term of protection. Finally, remember that the U.S. government neither reviews nor regulates trade secrets, so it would be up to the individual or the business to maintain the trade secret. And then one last note here about trade secrets is that the Defend Trade Secrets Act of 2016 made it possible for an owner of a trade secret to sue an entity in federal court when their trade secrets have been misappropriated. For example, if a former employee leaves the company and tells a competitor the trade secret, they would be held liable in a federal lawsuit. So we do see here some famous trade secrets, right, which include the KFC 11 herbs and spices and the core Google search algorithm. Possibly what may come to mind as a famous trade secret is the recipe for Coca-Cola. So if you have formulas, patterns, programs, methods, techniques, or processes, you may want to consider protection via trade secret. And there are different factors to consider when determining to use a trade secret as your means of IP protection, which may include figuring out what the value is and having information against your competitors, what precautions are taken to guard that information, what is the amount of money and effort you must expend in obtaining and developing the information, and evaluating the time and expense for others to acquire or duplicate your trade secret information. Now, on to copyrights. So a copyright is a form of protection provided by the laws of the United States to the authors of original works of authorship, right? Those may include literary, dramatic, musical, artistic, and certain other intellectual works. A copyright is a bundle of rights that would give the owner the exclusive right to make and distribute copies, prepare modified works, perform or display the work publicly, and sell or license that intellectual property. So it is important to note that we are all copyright users. When we read books, watch movies, listen to music, play video games, or even use software, we are using copyright protected works. So even if you are not the owner of a work, you may still be able to use it. And in addition to buying or licensing works, you can also use one of the Copyright Act's exceptions and limitations, which can be found in Chapter 1 of Title 17 of the United States Code, or rely on works in the public domain. Now, works in the public domain are those that are never protected by copyright, such as facts or discoveries, or they may be works whose term of protection has either ended because it expired or the owner didn't satisfy previously required formalities. Currently, copyright protection has expired on all works first published in the U.S. before 1930 and all sound recordings published in the U.S. before 1925 and thus are in the public domain. You may be thinking about the original Mickey Mouse from the 1928 animated short Steamboat Willie, which entered the public domain on January 1st of 2024. Similarly, the original Winnie the Pooh is in public domain since 2020. Disney may still hold copyrights and trademarks of different versions of those characters, however. It is important to note what is not protected by copyright are works that are not fixed in a tangible form of expression, titles, names, familiar symbols or designs, or just mere variation of lettering, or mere listings of ingredients or content. Individual words and short phrases are not protected by copyright. Ideas, procedures, concepts, principles, or works of the U.S. government. The term for copyrights is the life of an author plus 70 years after the author's death. So for works made for hire or anonymous works, copyright protection would be 95 years from publication or 120 years from creation, whichever is shorter. For more information, I encourage you to visit copyright.gov. The U.S. Copyright Office is the federal agency responsible for registering U.S. Copyrights. The U.S. Copyright Office is a part of the Library of Congress, so a separate agency from the U.S. Patent and Trademark Office, but the two agencies do work together to develop intellectual property policy. I do want to note, before I go leave the topic of copyrights, that copyright protection is secured automatically upon creation. So a work is created when it is fixed in a copy for the first time. No publication or registration is required. However, there are certain advantages to federal registration of a copyright. It puts others on notice of the copyright claim. A copyright registration is required to file suit in federal court for works of U.S. origin. It provides prima facie evidence of validity of the copyright and facts in the certificate. And registration may be used to be recorded with U.S. Customs and Border Protection, or CBP, to help prevent importation of pirated products into the U.S. Statutory damages and attorney fees may be available in litigation only if registration is obtained within 3 months after the publication of the work or prior to infringement of the work. And it is easier to license work, collect royalties, and enforce rights outside of court with that federal registration. Let's move on to trademarks. So what is a trademark? Just to keep it simple, a trademark indicates the source of goods and services. Let's talk about how trademark rights and how they were created, because they're really created in two ways. First, there is common law. Under common law, as soon as you start to use something that has your trademark to indicate the source of your goods or services, you're essentially creating trademark rights. There are typically state laws governing common law trademarks for each state. Common law trademark seems like a great way to avoid paperwork and filing fee. However, under common law, your trademark rights are limited to the geographic area in which your trademark is issued. For instance, if someone opens a food truck in Seattle, that operates in Seattle, and they're only going to have those common law trademark rights to their name and logo in Seattle. Under common law, the food truck can still use the TM circle, or if you are providing a service, you can use that encircled SM, but you cannot use the encircled R symbol. The second way to enforce your trademark law is through trademark registration with the USPTO. Once registered, the business can now use that encircled R in conjunction with your trademark, right? Meaning that encircled R puts everyone on notice that you now have that federal registration. So a registered trademark gives that legal presumption of ownership and grants those exclusive rights to use the mark in the entire U.S. in connection with your goods or service listed in the registration. So if you own a growing business and wish to expand your business outside of your local metro area or outside of the state, then registering your trademark with the USPTO will provide you with that nationwide coverage. You'd also be better equipped to protect your trademark if it is registered because it'll give you the ability to bring an action in federal court. Additionally, having that federal registration allows you to record it with U.S. Customs and Border Protection to prevent importation or infringing foreign goods. Without recording with Customs, the government is powerless to stop infringing goods. When your trademark is published in the official gazette, notice is implied, which is called constructive notice. Another benefit is that U.S. registration can be used for a basis for filing in another country, but there is no presumption related to use or ownership. Again, each country requires its own trademark filing. And then one last note, we are a first to use country, whereas most other countries are the first to file for trademarks. As we see here, some examples of famous trademarks as you're looking at these, right? The words Starbucks, Nike, and Target are likely bringing to mind coffee, sports apparel, retailer. Likewise, you can look at these designs or these logos and you would also bring to mind coffee, sports apparel, retailers. So trademarks can be words or they can be designs, right? But we know that these words and designs immediately indicate the source of goods, again, by either the word or the design. So trademarks do extend beyond the words and logos. It can include sounds like the MGM roar or the Pillsbury Doughboy giggle, color shades like the UPS brown or the John Deere green and yellow, smells like the vanilla musk of Play-Doh or a unique aroma used in Verizon stores if you've ever noticed. Product packaging such as the Coca-Cola bottle that we see here or the Hershey's Kiss wrapper are also examples of trademarks extending beyond words and logos. And then finally, trade dress, which can include store designs like Apple stores and Starbucks cafes. They specifically design their stores to be recognizable identifiers of their brand. So you might be thinking about some companies that share a similar name and differing classes of goods. For instance, let's look at the Dove trademark in the class of goods that includes soap, and the Dove trademark in the class of goods that includes chocolate and ice cream bars, which are owned by separate companies, but they can coexist without infringing because they belong in different classes of goods. Similarly, we have Delta Airlines, Delta Faucets, and Delta Dental. And for those same reasons, each of the trademark owners can own their Delta trademark without infringing on the other Delta trademark in different classes of goods. Now, I do want to note here that domain name registration of your website and trade name registrations for your state business license do not equate a registered trademark. These are totally separate processes, right? Your domain name is simply establishing a web address for your website, while that trade name or your business name registrations allows you to do business in a particular state or jurisdiction. You may use your trade name as your trademark. You have to assign it a class, have either your word or your logo, and again, you may exercise either the common law or federal registration benefits associated with your registered trademark. So a final note, there are fees for your trademark registration. And earlier I mentioned a class of goods. When you register a trademark, you must select the class or classes of goods where you wish to register your trademark. The base application for a trademark is $350 per class using our online trademark center. Additional fees may apply if you make certain choices in the application. So keep in mind, to register in a class of goods, you should be operating in a class of goods or actively planning to be operating in that class of goods soon. Once registered, there is a $325 fee per class after 5 years from the registration date, and then another $650 fee per class after 9 years. After that point, you pay a renewal fee every 10 years from then if you are still using that trademark in connection with those registered goods or services in commerce. So again, this was just a brief overview of trademarks. There's certainly more to learn. In addition to this Path to a Patent series, the USPTO also does present an 8-part trademark basics bootcamp series that goes into more detail about trademarks and the federal trademark registration process. You can find those dates and links on our USPTO event page. So let's hop into patent basics. A U.S. patent is a property granted by the U.S. government to an inventor, and it gives the right to exclude others from making, selling, using, or importing the invention throughout the U.S. for the duration of your patent term. So in exchange for this protection, a patent application provides public disclosure of the invention so that the public may benefit from it and expand upon it. You may be thinking, why should I get a patent? Well, patents gives the entry into a market. It can deter others from entering the market, and you can use patent rights as collateral for funding. They may also help create revenue from licensing or sales, and you can use patents as a marketing tool. So the moment you file for a provisional or non-provisional application, you can begin to market your product as patent pending. So earlier I showed the steps, so we're going to start to go through these steps. Let's move into determining if your patent is, or if your invention is patentable. So to measure eligibility, we refer to 35 U.S. Code 101. And in essence, your idea has to be a process, a machine, an article manufacturer, or a composition of matter. Just to kind of give a few definitions here, a process is a method, operation, or series of actions intended to achieve some result. So, for example, that would be the process to, say, manufacture a lens, which would include cutting and etching and molding steps. A machine would be considered a device consisting of fixed or moving parts that work together to form some function. An example would be a device like a handheld camera. And then an article of manufacture is a thing that is man-made or machine-made, as distinguished from something that is a product of nature. So a good example of manufacture would be a trash bin, because it does have utility, but is not considered a machine. And then a composition of matter is material composed of 2 or more different substances. Composition of matter examples include pharmaceutical drugs or a special form of adhesives. So if your idea falls into one of these categories, then it would overcome 35 USC 101. It is important to note what is not patentable: law of nature, physical phenomenon, these abstract ideas, right? You must be able to describe how your invention functions or how it works. Literary, dramatic, musical, and artistic works, as you may have heard me mention earlier in the presentation, those may fall under protection as copyright material, right? So it cannot be patented. So one of the things that you would want to determine is if your invention already exists. So when you have an idea for a new product, a prior art study is first conducted and can be helpful in understanding the landscape of your field of invention. When you conduct that prior art study, which is done by examiners, or it may be done by yourself or your IP attorney, what's taking place is understanding the field of invention. Is it crowded? Are there opportunities for innovation? Who are the competitors in that field? Or it may even be to sharpen your invention to differentiate it from competitors or something that is already invented. So patent law in the U.S. according to that patent law, an invention cannot be patented if the claimed invention was previously patented, described in a printed publication, in public use, on sale, or available to the public before the effective filing date of the claimed invention. Another component of determining patentability is determining if that invention is new and non-obvious. So again, when patent examiners are examining applications, they will search through publicly disclosed or available information to determine if your invention or something similar is out there. And some of the information that they would look through includes, for instance, U.S. patents, foreign patents, printed publications, and the internet, websites, the videos. All of those things comprise that search. They're examined. So you can do a similar search of these sources before you file to determine if your invention or something similar is out there. And as part of our Path 3 of this series, which is focused on patent searching, that will be offered November 6th. And so we will present on the process of patent searching and how those search findings are used to determine patentability. As we move into the next step, now that you've determined if your invention is patentable, next is determining what type of patent you need. So there are 3 different types of patents that you can apply for. The first being a utility patent, which is the most common type and make up the bulk of the patent applications that we receive. Some examples of patent utility patents include mobile devices, fertilizers, and new drugs with unique health benefits. The other 2 include design patents and plant patents. For utility and plant patents, your term of protection would be 20 years after the filing date. And for a design patent, your term would be 15 years after the patent grant date. Now, for a design patent, it is more about the ornamental structure or the shape of the device, not necessarily how the device works. Think of an example for a design patent, maybe jewelry, packaging, or computer icons like emojis. The third type of patent, pictured here, the plant patent, includes a new variety of plant patents that are asexually reproduced. So you may be familiar with, say, cotton candy grapes that are available at your local grocery store. Those would be recognized as a plant patent. So after you've determined what type of patent you need, you'll next want to get ready to apply. For a utility patent, you have the choice of filing a provisional application or a non-provisional application. A provisional application must fully support whatever subject matter will eventually be claimed in order to preserve your filing date. That provisional application establishes your filing date for your invention, and there are no claims required, and it is less expensive. One thing to note about the provisional application, it is not published and it is not examined. So just filing that provisional application on its own will not result in an actual patent. Provisional applications are valid for 1 year. So essentially it gives you 12 months to pursue the non-provisional application on your invention. If you decide to file for a non-provisional application, this is the application that actually gets examined by your patent examiner, and it may result in a patent. It is published 18 months after your application's earliest filing date. And remember, if it's carrying over those claims from the provisional application, you'll be able to take advantage of the filing date from your provisional. And there are the statutory requirements that must be fulfilled for what gets filed in order to result in a patent. Again, in order for your non-provisional application to get the full benefit of your provisional application's filing date, the provisional must fully support whatever subject matter that will be claimed in the non-provisional. So with regards to a patent term, the patent term is measured from the filing date of the subsequent non-provisional application. It is important to note that there are not provisional applications available for design patents. And when we go into part 2 of the patent Path to a Patent series, which will be next week, there'll be more discussion on provisional patent applications. Let's discuss cost. This is one of the questions that we often get. Filing fees for provisional application for a large entity is $325. For a small entity, $130, which is approximately a 60% discount. And for a micro entity, $65, which is an 80% discounted fee. For non-provisional application, initial costs range from $400 for a micro entity to $2,000 for a standard fee. This excludes any attorney's fees, which can be anywhere from approximately $6,000 to $18,000, depending on the invention complexity. Now, there are some additional USPTO fees, for example, filing claims in excess of 20 claims or in excess of 3 independent claims, fees for late responses to office actions, non-electronic filing fees, etc. So again, you see these initial costs. These are just the filing fees. These do not include those additional attorney fees or non-standard fees that may be required. On the previous slide, I spoke about small entity and micro entity. Small entity is given to inventors that are either individuals, nonprofits, or small businesses defined as 500 employees or less. And micro entity status is given to any small entity that has filed no more than 4 previous applications, income is not greater than 3 times the median income, and the application has not been assigned to another entity outside of a micro entity. So that last part means is that you must not be under any obligation to assign, grant, or convey a license or other ownership to another entity that does not meet the micro entity income or number of patent application requirements. Now we're moving into preparing and submitting your initial application. So the parts of the patent application include an abstract, written description, drawings, and claims. The abstract is just a short description of the invention using between 50 and 150 words. And yes, it is that specific. The specification is a written description of how the invention works and how it is made and used. And then drawings often include multiple views of what the invention looks like. Patent claims are the inventor's attempt to delineate by way of a single sentence in the English language what they regard as their invention. Claim language defines, again, those meat and bounds of property protection desired. And then every issued patent contains 1 or more claims. Filing your application is done online using our Patent Center. You would upload those necessary documents, make the payment of required fees, and then you would receive a receipt from the USPTO providing your application number and your filing date. And remember, that filing date is what is going to be important to you. The U.S. is a first to file country, and so if there was ever a dispute as to who holds rights, we will be looking at that filing date. So now we're moving into working with your examiner. And here is just a simplified version of patent examination process. And we will go through some of the steps here in detail so that you get an understanding of what patent examination is all about. So essentially, an application filed by an inventor or an assignee is received by the USPTO, and based on the classification of the patent application, it will be assigned to an examiner in that specific technology area. So whether you have an invention that is based in mechanical art, perhaps electrical engineering, right? It is assigned to an examiner with that background. A majority of the times, after your application has been received, a non-final office action will be issued to the applicant, or you may even receive a notice of allowance. If you do receive a rejection, it is part of the negotiation to revise your claim, so please do not feel discouraged. This is part of that process to determine patentability. An applicant will typically respond appropriately by amending or arguing to clarify their position. Your attorney may also be responding on your behalf. And at this point, a second examination occurs, and then usually, but not always, a final office action is issued. At that point, an applicant has an option to appeal, which that will be reviewed by our Patent Trial and Appeal Board, or they may choose to abandon the application. There is also the option to pursue amendment of the claims after the two initial examination and file for request for consideration until novelty is determined by resolving the issues with the examiner to receive a notice of allowance. Once all statutory hurdles are overcome, an applicant will receive an issued patent. Okay? So this is the hopes of filers to receive that patent here, as you see here. So we've reached the last step. After the patent is granted, there are maintenance fees for utility patents that are due at 3.5, 7.5, and 11.5 years after the patent issue date to maintain the ability to be enforced. So, on one very important note about intellectual property, the USPTO is not an enforcement agency. As the owner of IP, you are responsible to enforce your IP rights. Otherwise, you can easily lose the value of your IP. You can do so by monitoring the marketplace, publications, and the internet for possible innovations similar to your patent, or even for counterfeit goods and services using your trademarks or even unauthorized copies of your copyrighted patents or writings. If you do discover possible infringement of your IP, then you should consider how to stop the infringement, prevent any further violations, and seek possible remedies. So some legal actions may include sending a cease and desist notice to the infringer, seeking compensation for damages, and filing lawsuits in court. So the federal government, including the USPTO, again, does not enforce the IP for you. But there are some resources that can help, such as the multi-agency Stop Fakes platform with tools and resources on IP rights, and the U.S. Customs and Border Protection Agency IP e-recordation program. So I'll give you some additional information shortly. So before I do conclude, I think it's extremely important for you all to know that there is help available to you through the USPTO. So first, I do want to present to you accessing our free resources, which there are a plethora of resources there for application assistance, education and training, help appealing or fixing an issue, and more services that support that full spectrum of customer needs. So whether you are an independent patent and trademark filer or an experienced attorney and business advisor, again, I encourage you to take a look at these free services, which you can filter by, as you see, learning the essentials, preparing to file, applying for protection, right? There are even resources for protecting your rights abroad. As you navigate to our homepage at uspto.gov, in the top left corner, if you click on patents, you will see a link that provides you to resources for patents. And so this will include information such as fees, the examination process. Then there are also resources for our Inventors Assistance Center. Again, a plethora of resources there if you are seeking that patent protection and filing assistance can all be found there. And before I advance, I do also want to note, kind of going across, there is also a similar webpage for trademarks, which you will see located just to the right of that patents tab. So again, trademark application assistance, fees, where to find resources such as attorneys or agents, as well as, particularly for trademarks, how to prevent or identify a scam. So there are resources if you receive those phone calls, if you receive those emails, how to identify and protect yourself from scams, particularly in the area of trademarks. And then we also have an IP identifier tool that can help you determine what type of IP is right for you. So if you have a new idea and you're not quite sure, is patent protection applicable? Trademark? Is it copyrights? Should you be considering trade secret? And or should you be layering those IP protections? Using that IP identifier tool is a great way to help you delineate between the different types of IP, as well as point you down the track of IP protection resources. And so as part of the utility patent guide, you'll see just about in the middle of your screen that IP identifier tool, which is listed there, and it will take you to that site to utilize that tool. For patents, if you need to expedite your application, effective July 8th of this year, the limit on the number of Track 1 prioritized application requests that may be accepted has increased from 15,000 to 20,000. It does take on average 24 to 36 months to get a first office action, but the Track 1 program does provide final disposition within about 12 months, and that may be fluctuating just a bit here. And so if you're seeking that, again, prioritized examination, Track 1 is available for utility and plant applications. I mentioned earlier stopfakes.gov, which is administered by the International Trade Administration under the U.S. Department of Commerce. They manage that stopfakes.gov program to assist small businesses and businesses at large in protecting and enforcing their IP rights against counterfeits and pirated goods abroad. So on that site, you can find information, guidance, and trainings by industry and by country of interest to protect your intellectual property rights, again, abroad or for those goods coming into the U.S. And I spoke about U.S. Customs and Border Protection assisting with enforcement. So they can assist by seizing goods from entering the U.S. that violate registered trademark or copyrights. So to enforce protection with CBP, right holders can register their copyright or trademark using the e-recordation program for $190 for each trademark per class of goods and $190 per copyright. So again, they are stopping those goods from coming into the U.S. We also have our Inventors Assistance Center, which is staffed by former supervisory patent examiners and experienced primary examiners who answer general questions about the patent examination policy and procedure. So contacting the Inventors Assistance Center can assist you with forms needed and with filling out the forms, direct your calls to the appropriate USPTO personnel, and provide you with general information concerning examining rules, procedures, and fees. What they cannot do, they cannot provide any legal advice or give an opinion as to whether your invention is patentable, and they cannot provide patent searches or intellectual property research for you. So you do want to keep in mind, again, this is general guidance to assist you through policies and procedures. So I did mention I'm located here in Detroit. My colleagues that are joining us online are out of Virginia as well as San Jose, California. But everywhere in between, we also have a network of patent and trademark resource centers, which are a network of public and academic libraries designated by the USPTO to help disseminate some of this patent and trademark information. So you may locate a PTRC closest to you and walk in to assist you then with patent searches and additional information as you prepare to file your patent or your trademark application. So that information is found there at uspto.gov/PTRC. Lastly, I mentioned our patent public search tool, or conducting a patent public search prior to submitting your patent application. So we do have the public search tool for applications for patents and patent application publications. You can select your basic search to look for patents by keywords or common fields such as inventor or publication number. And then there's also the option for advanced search to use full queries to further filter patent search by a database or organize documents through tagging. So again, that searching prior to submission of your patent application is encouraged.